While many Americans spent the 4th of July with their families, enjoying cooking out on the grill and drinking any beer that is not named Bud Light, a judge in the Western District of Louisiana handed down a ruling that is possibly the most impactful decision regarding free speech in America since the 1960s. What did he have to say? Hang on, folks. We're going to get into all that in just one second. My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk. A federal judge in western Louisiana today handed down a ruling that reminded all Americans why it is the founding fathers decided to declare us a free and independent nation and what it is that we have fought and died for to protect these almost 250 years by handing down one of the biggest rulings regarding free speech in America that has come down the pipe in years. So let's take a look at an article that tells us what exactly happened, what this is all about, and then we're going to analyze the implications going forward. So we go to an article from the Epoch Times, headline: Judge delivers major blow to Biden administration in social media censorship case. In an article written by Tom Ozimek, we read the following. A federal judge has made a historic ruling by partially granting an injunction that blocks various Biden administration officials and government agencies, such as the Justice Department and the FBI, from working with big tech firms to censor posts on social media. The injunction came in response to a censorship by proxy lawsuit brought by the attorneys general in Louisiana and Missouri, who have accused the Biden administration and its officials and various government agencies of pressuring social media companies to suspend accounts or take down posts. Judge Terry A. Doughty of the U.S. District Court for the Western District of Louisiana wrote in the July 4th ruling that various government agencies, including the Cyber and Infrastructure Agency, the Department of Homeland Security, the U.S. State Department, the Department of Justice, and the Centers for Disease Control and Prevention, are prohibited from taking a range of actions regarding social media companies. Specifically, the agencies and their staff members are prohibited from meeting or contacting by phone, email, or text message, or, quote, encouraging in any communication of any kind with social media companies urging, encouraging, pressuring, or inducing in any manner for removal, deletion, suppression, or reduction of content containing protected free speech per the injunction. The agencies are also barred from flagging content on posts on social media platforms and forwarding them to companies with requests for action, such as removing or otherwise suppressing their reach. Encouraging or otherwise egging on social media companies to change their guidelines for the removal, suppression, or reduction of content that contains protected free speech by the government also is not allowed. Quote, this could be arguably one of the most important First Amendment cases in modern history. Louisiana Attorney General Jeff Landry, one of the plaintiffs, told the Epoch Times American thought leaders in an interview following the ruling. If you look at the opinion that the judge lays out, he takes from our argument that this is basically one of the most massive undertakings of the federal government to limit American speech in the history of our country. The things that were uncovered in this case should be both shocking, appalling, and concerning for all Americans. Doughty, a Trump appointee, wrote in the decision that the Republican attorney generals who sued the Biden administration, quote, have produced evidence of a massive effort by defendants from the White House to the federal agencies to suppress free speech based on its content. While the judge's ruling isn't final, the preliminary injunction is a victory for the Republican attorneys general who have accused the Biden administration of pressuring big tech companies to engage in censorship by proxy scheme. Quote, I think that this injunction today certainly begins curtailing government action and telling social media companies what they can and cannot allow on their platforms. The judge wrote in an accompanying memorandum that the plaintiffs are, quote, likely to succeed on the merits in establishing that the government has used its power to silence opposition. Ladies and gentlemen, this has got to be one of the biggest rulings that I've seen in years on the question of free speech. Now, let me back this up and set the table of how we got here. Back in March of this year, the two attorney generals, one from Missouri and one from Louisiana, brought suit in federal court claiming that the Biden administration and various agencies of the federal government were engaged in a conspiracy, for lack of a better term. I'm not saying that's what they formally charged them with, but for the purposes of discussion, a conspiracy, more or less, to get big tech companies, YouTube, Twitter, Facebook, Google, etc., to suppress free speech, if not outright take it down altogether, on any number of different subjects, be it COVID, be it masks, be it alternative treatments for COVID, on the Hunter Biden laptop, whatever it may be. Now, the suit has moved forward to the point now that evidence is being gathered, it's being presented. Now, will this injunction stand? I don't know. Undoubtedly, it's going to be appealed because there's no way that the Biden administration could let this go without answering it. Because if that's the case for the remainder while this trial is going on in federal court, for all intents and purposes, the federal government is prohibited from talking to big tech companies. Now, that said, however, there are exceptions to that, and let me read you from the article just to make sure we give full context here. However, the judge did make some exceptions in his order, allowing government officials to contact social media companies to alert them of criminal activity or threats to national security. Also allowed are contacts notifying social media companies about posts intending to mislead voters about voting requirements or procedures, as well as communicating with companies about suppressing posts that aren't protected free speech. Now, some people are going to say, well, that last part, well, no, wait a minute, remember how it's worded, contacting companies about suppressing posts that aren't protected free speech. In other words, if some company is making some statement that obviously is not covered by the First Amendment, look, that's something that should be so blatant. Yes, that should be dealt with. Almost anything else is now, you can talk about it. Now, like I said, will this ruling stand? Who can say? Undoubtedly, it will be appealed. I'll be shocked if the Biden administration doesn't take this up. And ultimately, this one's going to wind up in the hands of the United States Supreme Court. There's no way that as a nation that we can go on in a society where some subjects are allowed to be talked about on social media and some aren't. There are unresolved questions that have been going on for years now. What is the role of a social media platform? Is it simply to allow a place for free speech to be engaged in? Or does a social media platform have a editorial responsibility to censor the kind of speech on their platform? And what are the limits of free speech in social media? What can you say? What can't you say? The Supreme Court is going to have to take this up at some point, and I'm fairly itching for them to do it. Because honestly, we need some guidance here. This cannot continue. So today is a huge ruling on behalf of people who are in favor of free speech. Now, one last point. You might read that article and wonder, well, just who exactly is prohibited from contacting these social media companies? Would you like a list? Try this on for size. The Department of Homeland Security, the National Institute of Allergies and Infectious Diseases, the CDC, the FBI, the Department of Justice, the White House Counsel, the White House Press Secretary, the Cybersecurity and Infrastructure Security Agency, Department of Homeland Security, the Department of State, more or less anyone in the federal government. They cannot, and by the way, not just departments, there are specific individuals who are named in this ruling that they can't reach out to these social media companies except for the handful of tiny exceptions that the judge laid down in his ruling about all this. So, free speech advocates celebrate the day the 4th of July is better than normal. But that's what I've got to say about it. What do you think? As we start to wrap up this video, as always, please do me some favors. Number one, if you are not a subscriber to this channel, please do so. Number two, please hit the bell for notifications. I want to make sure that you're always aware when we've got a new video coming out. Number three, please share the video around to friends of yours that you think would enjoy this content and they themselves might want to subscribe to the channel. And number four, please give me a thumbs up. My name is Brian Trippett. I am your Front Porch Conservative, and I'll see you next time.